Hi, I'm Paul Rabalais, an estate planning attorney and founder of the American Estate Planning Series. Today, I'm going to walk you through the Texas Statutory Power of Attorney so you understand the important decisions involved and why this document matters. And if you want the exact Texas statutory form that I'm showing you, along with additional estate planning documents, the Amazon link to my book, where you can get a free access code and download all of these documents, the link to my book, Estate Planning in Texas, is in the description below. Okay, a power of attorney, or sometimes people call it POA, allows someone you trust to handle financial and legal matters for you if you're unable to do so for yourself. Really, every adult in Texas needs a power of attorney, not just older adults. Accidents, illness, or unexpected events can happen at any age. And without a power of attorney in place, your loved ones may have no legal authority to act for you when you need help the most. One of the most important reasons to have a power of attorney is to help your family avoid a guardianship proceeding. Without a power of attorney, if you become incapacitated, a court may need to appoint a guardian to manage your affairs. Guardianships are expensive, time-consuming, and stressful. They involve ongoing court supervision, formal reporting requirements, and a loss of privacy and flexibility. A properly executed power of attorney can often prevent all of that by allowing someone you choose to act immediately on your behalf. Now, Texas provides a statutory power of attorney created by the legislature, and this form is often preferred. Banks, financial institutions, and other organizations are very familiar with it because it's standardized and widely used. That familiarity can make it much easier for your agent to actually use the document when it's needed without unnecessary delays or pushbacks. Okay, so let me pop the up on the screen here, and we'll take a look at it. Okay. So here we've got the statutory durable power of attorney. Again, if you get my book, Estate Planning in Texas, the link's in the description. You'll get a free access code where you can download this and many other Texas-specific forms. But this is the Texas statutory power of attorney. And again, it's really important that you designate the right person, because that person you select will likely have power of attorney for you for decades, because their power, it doesn't lapse or end at a certain date. It doesn't discontinue until you die or revoke your power of attorney. And very rarely do people revoke their power of attorney. So this, because it's effective for the rest of your lifetime, it can be in effect for decades. So probably your most important decision, and there's a lot of decisions you have to make when you create a power of attorney, involves who is your agent. So we created the form that you can download from my book where you can input information. So let's say your name is Fred Flintstone, and you'll see as you write in Fred's name, it gets populated elsewhere. You know, he lives on 123 Rocky Road, blah, blah, blah. And he appoints, let's say he appoints, very likely if he's married, he'll appoint his wife, Wilma Flintstone, Flintstone, as his agent. And again, she also lives at 123 Rocky Road. You know, of course, we put all the city and all that. So that's the most important decision Fred makes, was who is his agent. Yes, you can appoint co-agents. We kind of prefer making it simple and designating one agent and then a backup. And you'll see later in the power of attorney where you can designate a backup. All right, let's get into some of the powers. So you have the ability to grant certain powers or withhold certain powers. So if you want to grant your agent the authority to handle the sale of your home, for example, that's in your name, you might initial real property transactions. You don't need to, but maybe if you didn't want them to handle stock and bond transactions, you'd strike a line through that. But I think what most people do, and kind of the easiest way to do it, is you just put your initials by letter O, where you're authorizing your agent to handle all of those powers. Because if you're designating someone you trust, you want to make it easy for them. You never know what they might need to do for you at some point during your lifetime. So most people just initial O, all of which includes you're granting your agent the power to do all of the powers listed in A through N. Okay, now here's a tricky one. This one, the next part involves agent compensation. So in my mind, agent compensation, and not so much when Fred is appointing Wilma as his agent, because Wilma would kind of be spending her own money if she paid herself compensation. But this is more of an issue if you name perhaps one of your several adult children as your agent. And you can designate here whether your agent is not only entitled to reimbursement of reasonable expenses. Most people yet say, yeah, if my agent has to go spend some of their own money to do stuff for me, I would like my agent to be reimbursed. But then you can also designate whether you'd want your agent to be compensated. And if you do want your agent to be compensated, you can initial here where you provide that you'd want that compensation to be, quote, reasonable under the circumstances. Or if there's not good relationships among your children and you designate one of your children as your agent, then there could be an argument down the road about what reasonable compensation is. The child that you designated as your agent might say, I've been working hard for my dad, and as his agent under his power of attorney, I think reasonable compensation is $50,000. And then the other children may say, whoa, wait a second, that's not reasonable. All you did was pay a few of his bills and you dealt with his taxes. I think maybe a couple of $1,000s would be appropriate, but not $50,000. So there might be an argument about what is reasonable compensation if you authorize your agent to receive compensation that is, quote, reasonable under the circumstances. So be careful with that one. Then there's other portions about if you did designate co-agents. Again, we generally like to designate one and then a backup, but there's some initialing you can do if you really kind of insist that you have co-agents, whether they must act together, which is difficult. A lot of financial institutions won't work with two or more agents if they have to act together. So again, generally, it's a little easier if you do name co-agents to provide that they can act kind of independently, meaning any of those co-agents can act. So there's some decisions there. Then there's this portion about gifts. So it gets tricky when an agent makes a decision to gift some of your money to other people. So that could be tricky as well. But if you initial this authorization that your agent may make gifts of their assets on your behalf, when you initial this one, those gifts are limited to the annual exclusion amounts from the federal gift tax. So for 2026, that federal gift tax limitation is $19,000. So the most an agent could give someone is $19,000 per calendar year. Again, a lot of people who have the very large estates, their estate can save significant estate tax if gifts are made. However, the estate tax exemption for 2026 is $15 million. So there really is no tax need to make gifts as long as that estate is, under or even well under the $15 million estate tax exclusion amount. Next, they give you some lines on the statutory form that you can kind of write in your own powers where you limit or extend, powers granted to your agent. Again, most people leave this blank. The powers listed above, this kind of covers all the stuff that any reasonable agent may have to do. And so there really isn't necessary to kind of fill in. And whenever somebody starts writing this stuff in themselves, I always kind of shiver a little bit because I don't know what they're going to write. And I don't know if, 10 years later, when circumstances are different, what they wrote may not be practical. So you got that going. All right. And then there's another one as to whether the power of attorney that you sign is effective immediately or only upon your disability or incapacity. I think a lot of people like the idea that their power of attorney isn't effective until they are incapacitated. That's when it's going to need to be used. And as long as you can do things for yourself, your power of attorney has no power, no pun intended. But when you make your power of attorney and choose B, this power of attorney becomes effective upon my disability or incapacity. Then when your agent needs to use your power of attorney, they are likely going to have to prove to some third party that you are disabled or incapacitated. Whereas if your power of attorney, if you choose A, which is kind of the default, because if you don't choose either of these or don't cross one out, then alternative A is assumed. And if you make your power of attorney effective immediately and not affected by a subsequent disability or incapacity, then your agent, when they have to use your power of attorney, they won't have to go through this sometimes burdensome process of proving that you're disabled or incapacitated. In fact, the next paragraph is all about that. So if you do make it effective upon your disability or incapacity, now when your agent needs to use the power of attorney, your agent's going to have a physician visit with you. The physician is going to have to certify in writing that based on their medical examination that you are mentally incapable of managing your financial affairs. A lot of doctors sometimes are reluctant to sign those affidavits. So just be aware, you can make it effective immediately, which is simpler for your agent down the road, or you can make it effective only when you're disabled or incapacitated. And then just some kind of typical language. And here's where you could designate your successor, Arnie Rebel, or whatever his name is, or maybe one of Fred's adult children, list his address as well. And then you have to make sure, maybe the hardest part of this is, unless you work with an attorney, because if you work with an attorney, you'll go into their office and they'll make sure all the validity requirements are met. But if you try to fill this out on your own, the hardest part is making sure all these lines are filled in right and you sign in the presence of a notary, and all the notarization makes it valid and effective. And then the rest of it is just kind of some important information for your agent, and to really stress the importance of making sure that an agent does what they're supposed to do and generally acting in the best interest of the principal or the person who made this power of attorney. Okay, so there you have that. That should get you through kind of a starting to understand what a Texas power of attorney is all about. Again, if you want that exact form already preloaded, where once you fill in your name, it puts it in the form and puts it everywhere it needs to be in the form. You can get that by purchasing my book, Estate Planning in Texas. The link is in the description. And then there's a free access code in the book where you can download your power of attorney, your medical power of attorney, your living will. There's 6 different will forms you can look at to kind of get you started heading in the right direction. Okay, hope that helps. We'll see you next time.